All right, thank you all. Ms. Zook, I'm going to let you begin.
Thank you, Your Honor. I think that the topic for discussion and the tentative ruling highlights the importance of this case and also why it is that validation actions are entitled to statutory preference in trial settings and have to be speedily heard and determined. There can be, in terms of the bonds that were authorized, there can be no marketing or selling of the bonds until the final judgment in this case. And those are the bonds that go to the very purpose of the high-speed rail authority, their statutory purpose, what it's supposed to do when we're building a high-speed rail project. For instance, there have been appropriations by the legislature under 2704.08 G and H for administrative expenses and for planning out of these bond proceeds more than a year ago, that there are no bonds to sell in order to meet these appropriations. So every day has been and continues to be more critical in terms of selling bonds, in terms of getting the determination that the bonds are valid. The fact that these bonds are so crucial and that it's important that bond validity be established early and quickly is why it is that even when validation actions raise parallel issues, it's not appropriate to stay one in favor of the other. It's important that a case proceed as quickly as possible to judgment. And the fact that these bonds are so key and that time of the essence is reflected in the federal grant agreement. The federal government is currently spending money and they need assurances that the bonds are valid. That grant agreement reflects a spring bond sale as being a critical date under the agreement in terms of whether or not the authority can meet that date. And in fact, the authority has to report to the federal government, and even a delay in terms of reaching a judgment is something that is material to the federal government and required to report, because that's how urgent this issue is in terms of making sure that there is a judgment if bonds are valid and that hurdle can be crossed. But the fact of the matter is that...
What does that mean in terms of timing?
In terms of timing, there needs to be judgment in place to participate in the spring bond sale.
What does that mean in terms of timing?
Judgment has to be final. Spring bond sales begin in February, end in April.
How much time in advance of February is necessary for the bond sale to proceed?
Between final judgment and marketing and sale.
Is there a time frame associated with that?
No. But the defendants have requested a stay in this case, which is really related to all of their claims, which is use of proceeds. The fact is this is an in-rem action about bond validity. The issues in this case are really narrow. It's the authorization and sale. Is this legal? Is this a valid debt that can be repaid if it is issued? So areas of potential inquiry are, does this violate the Constitution? It doesn't. These are general obligation bonds. There's no issue with there being an interested pledge that we have to look into the legality of. This is a general obligation bond approved by the voters, approved by the legislature, for a specific purpose, high-speed rail. So the only inquiry then becomes, is this an authorization of the bonds that were authorized under the statute? In this case, it clearly is. The authority made a request as they were supposed to. The committee made a determination as they were supposed to, and they issued bonds for the purposes set forth in the statute. So there's no issue that either the authority or the committee exceeded their authority under the statute. And none of the other issues that are raised by defendants or these other cases are permissible areas of inquiry in this action. Because as the court is aware, issues with respect to uses of proceeds, funding, plan, and compliance under the Bond Act are not related to the narrow issue of whether or not the bonds are in fact valid. Are they a valid debt? Can they be repaid 2708.08I makes very clear that these are separate issues. How can these bonds be spent later is for cases down the road, and there's a large body of case law making challenges with respect to the project, but there's no issues that, how TOP turns out, whether or not CEQA applies fully, if CEQA remedies are preempted, or if NEPA is applied, or something else. Under the Bond Act and under the Constitution, these do not have anything to do with bond validity, which is the issue in this.
Do you think there was sufficient material before the committee to make the decision that the bond issuance was necessary and desirable?
I absolutely do.
Why is that?
Because the committee is required to make determinations that the bonds are necessary or desirable. Like, either or. This is a discretionary determination. But there was plenty of evidence. The key is that the authority has to make this request to the committee. This is the authority that is tasked with putting together the funding plan and putting together construction plans for the project. The fact that they are asking the committee, we need these bonds authorized, is a significant ask that has to be taken very seriously by the committee. They have discretion. They could ignore that ask, but there's certainly sufficient evidence as soon as the authority makes that request before them. And it's important to keep in mind, statutorily, these are individuals who are either heavily involved in the project themselves, are aware of funding needs, construction plans, or individuals who by statute participate in nearly every GO bond finance committee, so they're also aware of market conditions. But even under the Bond Act, these are bonds that are authorized for high-speed rail. Basically, when you have a request for bonds that are for the purpose of building this project, high-speed rail, I can't conceive of any way that you could determine that it wouldn't be desirable, that you could overturn that discretionary determination that it's desirable to authorize those bonds that are set forth in the statute to make that very project.
Would you argue that the request by the authority then was sufficient once the authority passed the resolution? Yes. All the committee really needed?
Yes.
Anything further?